The U.S. Supreme Court's decision in Endrew F. was in 2017, and it had to do with a young boy at that time, Endrew. He, at that time of the case, was in third, fourth grade, somewhere around there. He has autism, and a lot of his the manifestations of his autism resulted in some behavioral challenges. So for example, he might not attend to the school, he might disrupt his peers, he might get distracted himself. So there were a number of problems for him to fully access the educational services. And the school provided, what they thought was a sufficient IEP, or Individualized Education Plan. The parents wanted more because they thought what the school was offering was just simply not enough. And the parents pointed to the history of his academic progress. It just wasn't working out that well. And the parents were also saying that he had some access to some other services from a different group. And that group had a behavior plan that assisted him with managing his behavior that was related to his autism, and also that provider gave him some more additional supports. And so the parents were saying, well, look, these things work. We know it works. We have data that it works. And the school program, the school offer, just did not have those essential components. And the parents and the school district fought it out, and they fought it out all the way to the U.S. Supreme Court. Now, the U.S. Supreme Court did something kind of interesting in this case. So, you have the school district saying, well, the bar for the legal obligation is pretty low, it's right here. And the parents were saying, no, it's really up here. The U.S. Supreme Court said, both of you are wrong. It's somewhere in the middle. And while we can't give you objective standards on really what works, what we can do is to give you some more guidance. And some of that guidance includes language like the educational program, that IEP, must not only be reasonably calculated to provide a free, appropriate public education, it also must be appropriately ambitious in the child's individual circumstances. And that last part, that appropriately ambitious, is really the key to the Endrew F. decision, because it's saying that it's not only the plan, it's good, it's reasonable, it seems to make sense in some kind of way, but it also has to be appropriately ambitious to keep on pushing and to raise those expectations. And so while it wasn't that level that the parents wanted, it also wasn't the level that the school district wanted, but it's more of an individual characteristics, the unique circumstances of the child, and to really think about that plan, and is it appropriately ambitious to meet the kid's needs and also to have some good results in that kid's educational experience. So I think that the Endrew F. decision is a fundamentally important decision for everyone to know about, because it changes the level of expectations for parents and schools to meet when they're providing that education and developing that individualized education plan. So one fundamental thing about the U.S. Supreme Court decision is that it reviewed what the lower court or the circuit court stated. And the circuit court really adopted the argument of the school district. And the school district was basically saying, we have an obligation to provide some educational benefit or any educational benefit. And in some legal terms, it's kind of called the de minimis standard. In contrast, the parents were saying, no, that's not appropriate, because look at the context of the IDA. It's got to be more than something, a very bare minimal standard. It's got to be something more. It's got to be meaningful. And so what the parents were really pushing for was a standard that was education equal to the education provided to kids without disabilities. The court kind of backed off, and Justice Roberts, announcing the decision for the entire court, indicated that really this is not the very low de minimis standard, and it's not the equal access standard. It's somewhere in between, and we have to account for the individual needs, the unique circumstances of the student in developing the standard that school districts must meet. So again, it's that appropriately ambitious in light of the child's unique circumstances that is really the hallmark that schools, courts, parents really must attend to, recognize, and know when thinking about what special education really means in practice.